Today, we're going to explore franchises and other special forms within business law. We'll take a structured look at how franchise systems operate and examine alternative organizational forms that businesses can choose from under the law. This foundational overview will help us understand the key factors involved in selecting the appropriate legal entity for a business. As we move through this presentation, keep in mind how these frameworks impact the way businesses are structured and function legally, too. A franchise is essentially a business setup where one party, called the franchisor, grants another party, the franchisee, the right to operate a business using the franchisor's trademark, system, and brand. This arrangement is built on a formal agreement, where the franchisee pays fees upfront and ongoing royalties in return. One key aspect to understand is the brand license, which allows the franchisee to use the franchisor's name, logos, and overall commercial identity. This ensures consistency and recognition in the marketplace. Another critical component is the operating system. The franchisor provides detailed methods, training, and controls that the franchisee must follow. This standardization helps maintain quality and replicates the success of the original business. Finally, the consideration includes the initial fees the franchisee pays to join the franchise, as well as ongoing payments based on sales or set terms. Altogether, these elements create a structured business relationship governed by franchise law, which is a part of the broader law of business and business organizations. On this slide, we're looking at the fundamental aspects of the franchise relationship. At the core, we have the franchisor and the franchisee, each playing distinct but interconnected roles. The franchisor is responsible for licensing the brand, the business model, the training, and the operating standards. Essentially, they provide the blueprint for how the business should run. On the other hand, the franchisee owns the individual outlet, invests the necessary capital, and manages the daily operations, but always within the guidelines set by the franchisor. This creates a partnership based on a shared system where the brand is licensed to separate owners who operate locally. This dynamic is what drives the replication and consistency of the franchise model across different locations. Understanding this core relationship is crucial to grasping how franchises function successfully. Now let's dive into the key elements of a franchise agreement, which are essential for defining the relationship between the franchisor and franchisee. First, we have territory and exclusivity, which outlines the market boundaries within which the franchisee can operate, ensuring they have a defined area to develop their business without direct competition from the same franchise. Next, the payment structure is critical, covering initial fees that the franchisee pays upfront and ongoing royalties that support the franchisor's continued assistance and brand maintenance. Operating standards and training duties establish the system control, ensuring consistency in quality and service across all franchise locations through set guidelines and provided training. Trademark use and brand protection fall under intellectual property, safeguarding the franchise's brand identity and reputation. Lastly, terms regarding the duration of the agreement, renewal options, transfer procedures, and termination conditions are grouped under exit rights, helping both parties understand how the franchise relationship may evolve or conclude. These 5 provisions, market boundaries, payment structure, system control, intellectual property, and exit rights, are fundamental in controlling value and managing risks within a franchise agreement. Here, we're focusing on franchise law and specifically the Federal Trade Commission, or FTC, rules related to disclosure requirements. The FTC rule is all about ensuring transparency before the sale is made. This means that potential franchisees must receive key information upfront to make informed decisions. There are several required disclosure items the franchisor must provide. First, details about fees and estimated startup costs, so the buyer knows the financial commitment involved. Second, information on any litigation history, bankruptcies, or other significant background issues that could impact the business. Third, specifics about the territory, training programs, and operational support offered by the franchisor. And fourth, financial statements and a list of current franchisees, providing insight into the franchise's overall health and network. the compliance timeline is strict. The Franchise Disclosure Document, or FDD, has to be delivered at least 14 days before the prospective franchisee signs any agreement or makes a payment. This period is crucial as it gives them time to thoroughly review the risks, costs, and obligations involved before committing. This process helps protect both parties and promotes transparency in franchise transactions. The Franchise Disclosure Document, or FDD, is a crucial federal requirement that ensures prospective franchisees receive all the essential information before they decide to invest. This document lays out material facts about the franchisor and the franchise opportunity. For example, it includes the franchisor's background, their business experience, and any history of litigation. This helps potential franchisees understand who they're getting into business with. It also details all the fees and investments involved, covering startup costs as well as ongoing payments, so there are no surprises financially. Additionally, the FDD spells out the obligations and restrictions you'll face as a franchisee, such as limitations on your operations, designated territories, approved suppliers, and how renewals are handled. Finally, it includes financial statements and any earnings claims made under the federal rule, providing transparency about the financial health and potential profitability of the franchise. Overall, the FDD is designed to give you a comprehensive view of the franchise opportunity and protect your interests before the sale is finalized. When we talk about franchise law, it's important to remember that state overlay plays a big role because laws can vary quite a bit depending on the state. For instance, in some states like California in the West region, there is a registration requirement for franchises. This state also emphasizes strong pre-sale disclosure and provides robust protections for franchisees before they sign on. Moving over to the South, Texas stands out because it doesn't require franchise registration. However, franchisors operating there still have to be mindful of contract laws and deceptive practice claims, meaning they need to engage honestly and fairly. In the Northeast, New York requires registration and has a detailed filing review process in place. The state also enforces strict anti-fraud rules to protect franchisees and maintain a transparent marketplace. Overall, when dealing with business organizations and franchises, understanding these state-level differences is crucial because registration, disclosure timing, and enforcement mechanisms differ sharply across regions. This regional compliance snapshot helps clarify what to expect in each area and guides how franchisors should approach their legal obligations. When it comes to franchise termination, state laws play a crucial role in setting standards that franchisors must follow to end the relationship. This process typically involves two main phases. In Phase 1, the franchisor must establish good cause for termination. This usually means there has to be a material breach of the franchise agreement. The franchisee fails to fix the issue after being notified. Or there are repeated defaults that demonstrate a pattern of non-compliance. Moving to Phase 2, notice periods come into play. Franchisors generally need to provide a cure notice, often spanning around 30 days, giving the franchisee an opportunity to correct the problem. In cases where the franchisor chooses not to renew the agreement, a longer notice period of 60 to 90 days is commonly required. However, these timeframes can vary as some state statutes include exceptions or different requirements that franchisors must adhere to. Understanding these termination standards helps ensure the process is fair and lawful for both parties involved. When we talk about common franchise disputes, there are a few key areas where conflicts tend to arise. First, territorial encroachment is a frequent issue. This happens when franchisees feel that new outlets, online sales, or nearby licenses are cutting into their established market, impacting their business unfairly. Next, quality control disputes come up when franchisees believe that the franchisor's operating standards, inspections, or required changes are too strict or inconsistently applied. Finally, termination without cause is a major concern. Franchisees often challenge whether proper notice was given, is they had a fair chance to correct issues, and whether statutory protections were respected. These disputes highlight the delicate balance between maintaining brand consistency and respecting franchisee rights within the broader framework of franchise law. On this slide, we're focusing on franchise litigation trends and the types of claims that are emerging in this area. One key point is that disputes are increasingly centered around issues of control, exit strategies, and disclosure, rather than just isolated breaches. This shift means that conflicts often involve who has authority over the franchise system, the nature of the ongoing relationship, and restrictions that apply after the franchise agreement ends. When we look at the types of cases, termination and non-renewal issues stand out, particularly challenges involving good cause standards, defects in notice, and wrongful exits from the system. Then, there are misrepresentation and earnings claims, which typically involve gaps in disclosure, promises made about sales performance, and reliance on statements made before contracts were signed. As for remedies sought in these disputes, parties often request injunctions or specific relief. This might include court orders that block terminations, enforce restrictive covenants, or compel compliance with certain obligations. Additionally, damages are a common outcome, covering lost profits, statutory remedies, attorney's fees, and sometimes even the unwinding of the contract itself. Overall, the trends show a more complex and strategic landscape in franchise litigation, where control and disclosure are becoming central battlegrounds. Now let's talk about limited liability companies, or LLCs. An LLC combines the liability protection you find in corporations with the operational flexibility of non-corporate structures. This means that unlike a sole proprietorship, where the owner is personally liable for business debts and claims, an LLC separates the owner from much of that risk, providing a shield for personal assets. At the same time, LLCs avoid some of the formalities and complex governance requirements that corporations have, making them easier to manage. One of the biggest advantages is that LLCs often benefit from pass-through taxation, meaning the business itself doesn't pay taxes separately. Instead, profits and losses pass directly to the owner's personal tax returns. This blend of protection, flexibility, and tax advantages makes LLCs a popular choice for many business owners. An LLC is formed by first filing articles of organization with the state, which officially creates the entity under state law. After that, it's important to adopt an operating agreement. This agreement lays out the rules for ownership, voting rights, and how profits will be shared among members. Then we identify the members and their contributions, which could be in the form of cash, property, or services. And these contributions determine each member's interest in the LLC. Finally, the management structure is chosen. It can either be member-managed, where all members participate in running the business, or manager-managed, where designated managers handle operations. Essentially, the formation of an LLC is governed by statutory law through the filing process, but its ongoing governance is determined by the contractual operating agreement. This dual nature makes understanding both aspects crucial to setting up and running an LLC effectively. Now, let's take a closer look at how LLCs are treated for tax purposes. One of the main advantages of an LLC is that it avoids double taxation. Unlike corporations, LLC income typically passes directly through to its members. This means the income is reported on their individual tax returns, creating a single layer of taxation. On the other hand, C corporations face what's called double taxation. Profits are taxed once at the corporate level, and then again when those profits are distributed to shareholders. This distinction is crucial when deciding which business structure to choose, especially from a tax perspective. Now let's talk about piercing the LLC veil. Normally, limited liability protects the owners from being personally responsible for the company's debts or liabilities. However, this protection can be lost if the LLC is treated more like a facade than a genuine, separate business entity. There are several key conditions under which courts might pierce the veil. First, if the LLC is inadequately capitalized, meaning it doesn't have enough funds to cover its probable liabilities, that's a red flag. Second, if the owners commingle their personal assets with the LLC's assets, it blurs the line between the company and the individuals, which can lead to veil piercing. And third, if there's fraud or some form of misuse of the company, courts are more likely to hold the owners personally liable. Understanding these conditions is crucial in the context of business organizations law, because it highlights when limited liability can be challenged. Now, let's compare two main types of partnerships, general and limited. First, liability. In a general partnership, all partners are personally liable for the business's obligations. That means each partner can be held responsible for the full extent of any debts or legal actions. On the other hand, in a limited partnership, the general partner holds this liability, while the limited partners are protected and only risk their investment. Next, management. All partners in a general partnership have the right to participate in managing the business. However, in a limited partnership, management is exclusively handled by the general partner, and limited partners typically do not take part in day-to-day decisions. When it comes to capital, active or general, partners often pool resources to fund the partnership. Conversely, limited partners usually contribute capital but do not manage the business. Finally, profit distribution varies. In general partnerships, profits are shared either equally or according to an agreed-upon arrangement. In limited partnerships, profit allocation is specifically outlined in the partnership agreement. These four key attributes, liability, management, capital contribution, and profit distribution, clearly distinguish general partnerships from limited partnerships. Understanding these differences is essential for choosing the right structure for a business. When we talk about partnerships under partnership law, an important concept to understand is shared agency and shared risk. This means that any partner can legally bind the entire firm when acting in the ordinary course of business. So the actions of one partner can have significant implications for all. A partnership itself can be formed either through an explicit agreement or by the conduct of the parties involved. Essentially, if two or more people carry on a business together as co-owners with the intent to make a profit, a partnership may be established. Key factors that indicate the formation of a partnership include the partner's intent, sharing of profits, and participation in management. Typically, each partner has equal rights when it comes to making ordinary business decisions, unless the partnership agreement states differently. Beyond decision-making, core rights in a partnership include access to the company's books and records, a share of the profit, and fiduciary protections. These fiduciary duties require partners to act with loyalty and care toward each other and the partnership. Finally, it's important to note that default rules will apply in the absence of an agreement. However, partners always have the opportunity to contract around these defaults to tailor the partnership arrangement to their specific needs. Understanding these principles is essential for navigating partnership law effectively. When a partner exits a partnership, it's important to understand that this isn't just a single event. It's a legal process that unfolds step by step. First, there's the triggering event, which could be a partner withdrawing, the partnership term ending, an agreement between partners, the death of a partner, or even a court order. This event sets everything in motion. Next, we move to the legal dissolution phase. At this point, the partnership ceases taking on new business, except for what's necessary to wrap up existing matters. Then comes the winding up stage, where all assets are gathered, ongoing contracts are completed, claims are resolved, and any liabilities are paid off. Finally, there's the distribution of any remaining surplus. This is done according to the partnership agreement or the relevant statutes, and it's crucial to remember the order here. Creditors are paid first. And only after all debts are settled do the partners receive their share. This careful sequence ensures the partnership is properly and fairly closed out. Here, we're focusing on a key principle in cooperative business organizations, captured by the phrase "one member, one vote." This reflects the core idea that ownership follows participation. Unlike traditional companies where voting power depends on the number of shares owned, cooperatives operate on a democratic basis where each member has an equal say, regardless of their investment size. This structure promotes fairness and ensures that control and profits are shared among members for their mutual benefit, rather than prioritizing outside investors. Essentially, cooperatives are businesses owned and governed by their members, emphasizing participation and shared responsibility as the foundation of ownership. Here we're focusing on benefit corporations, a unique type of business organization designed to serve a purpose beyond just making profit. Unlike traditional corporations, benefit corporations have legal accountability to consider the impact of their decisions on all stakeholders, not just shareholders. This means they must balance financial goals with social and environmental responsibilities. Another key feature is public transparency, which requires them to openly report on their overall social and environmental performance. Essentially, this corporate form embeds public benefit duties directly into its structure, ensuring that business success is measured not only by profits, but by positive contributions to society as well. Now, let's compare S corporations and C corporations, which are two common types of corporate forms. Both provide a liability shield, protecting owners' personal assets, but they differ significantly in ownership rules, taxation, and structural flexibility. Starting with S corporations, they are considered pass-through entities, meaning income is passed directly to shareholders and taxed at their individual rates, avoiding double taxation. They can have a maximum of 100 shareholders, and all shareholders must be U.S. citizens or residents. Another key point is that S corporations can only issue one class of stock, simplifying the ownership structure. Also, an IRS election is required to qualify as an S corporation. On the other hand, C corporations are subject to corporate taxation, so the company pays taxes on its earnings, and shareholders also pay taxes on dividends. They can have an unlimited number of shareholders, and unlike S corporations, foreign owners are allowed. Additionally, C corporations can issue multiple classes of stock, offering more flexibility in structuring ownership. This structure is generally preferred when seeking outside investors. So, while both types offer liability protection, the choice between an S corporation and a C corporation depends on factors like your shareholder preferences, tax considerations, and plans for raising capital. Here, we're looking at special purpose entities, or SPEs, which are unique legal structures created to separate specific assets, risks, or obligations from the parent company. The main idea behind an SPE is asset isolation, meaning that it keeps certain assets and liabilities separate, so any financial exposure is contained within the SPE and doesn't impact the parent business beyond that scope. Another key use of SPEs is in securitization, where these entities hold receivables or pooled assets that can then be financed by issuing securities. This process helps in converting assets into liquid funds without directly affecting the parent company's balance sheet. SPEs also play a vital role in project finance. They support a single project, and because of this focus, lenders tend to rely primarily on the project's cash flow for repayment, rather than the broader financial strength of the sponsoring company. Overall, the institutional structure of SPEs provides a tailored framework that isolates risks, facilitates asset-backed financing, and enables specialized project funding, making them a powerful tool in sophisticated business and financial arrangements. When we talk about governance and compliance, it's really about protecting the entity by following formal processes. Good governance means keeping a clear record of lawful and deliberate business actions, which is crucial for maintaining the integrity and legal standing of the organization. First, annual filings are a core duty. This includes submitting reports, registrations, and fees on time. Missing these deadlines can not only result in penalties, but also risk the loss of the entity's good standing, which can have serious consequences. Next, maintaining corporate records is essential. This means preserving minutes from meetings, resolutions, and other key documents. These records support the authority of decisions made, ensure continuity over time, and provide a solid defense if legal questions arise. Tax obligations are another critical area. Entities must handle tax reporting carefully, considering the different requirements at the federal, state, and local levels. Failure to comply promptly can quickly undermine any strategic planning or tax advantages the business might have. Lastly, internal governance involves holding regular member or shareholder meetings with proper notices. These meetings and consistent procedures reinforce governance standards and validate important business decisions, helping to protect the organization and its stakeholders. In summary, strong governance and compliance practices form the backbone of a well-run business, securing both legal protection and operational success. When we look at liability protection across different business forms, it's important to understand how each structure affects the separation between the owner and the business. corporations and LLCs offer the strongest personal asset shield, providing maximum liability protection. This means that if the business incurs debts or legal issues, the owner's personal assets are generally protected. Partnerships, on the other hand, offer limited protection. Some types of partnerships protect certain partners, but not all, which means liability can still reach personal assets depending on the partnership type and agreement. Finally, sole proprietorships provide no liability protection because the owner and the business are legally the same entity. This means any business debts or liabilities directly affect the owner's personal assets. In essence, the legal form of the business determines whether business debts stay within the entity itself or extend to the owner personally, which is a critical factor when deciding how to structure your business. When deciding on the right business form, several key factors come into play. First, consider the startup stage. Early ventures usually benefit from simplicity, allowing founders to move quickly without getting bogged down by complex structures. However, as a company scales, more formal structures become necessary to support growth and manage increasing complexity. Next, think about the number of owners. A single owner might prefer a straightforward setup, while businesses with multiple investors need to accommodate differing interests and responsibilities. This difference can significantly impact the choice of business form. Tax goals are another crucial consideration. Some businesses might benefit from pass-through taxation, which allows income to be taxed only once at the owner level, while others may prefer the advantages of corporate taxation. Understanding how these tax treatments align with your financial goals is important in making the right choice. Finally, the legal form you select should reflect your operational reality, your tolerance for liability, and your plans for long-term growth. In essence, the form follows strategy. Choosing the right structure is not just a legal decision, it's a practical one that affects everything from daily operations to your future trajectory. Here we have an overview of recent developments in franchise law that are shaping the industry. Starting with 2021, courts actively examined pandemic-related force majeure clauses and operating obligations in franchise disputes, highlighting just how crucial precise contract language is, especially during times of stress. Moving to 2022, several states enhanced protections related to notice, cure periods, transfers, and non-renewals within franchise relationship laws. This shows us that state regulations can significantly impact and sometimes override leverage in franchise agreements. In 2023, the National Labor Relations Board adopted a broader approach to joint employer status, raising concerns about the extent of control franchisors can safely maintain without increasing labor liability. Finally, in 2024, federal scrutiny has intensified, particularly regarding earnings claims, fees, and disclosure transparency. The ongoing push for reform by the FTC makes clear that compliance now heavily depends on how transparent franchisors are with their disclosures. These trends emphasize that franchise stakeholders must stay vigilant in adapting to evolving legal landscapes. When expanding a franchise internationally, we face a complex set of challenges that go beyond simply replicating the business model abroad. Cross-border expansion transforms the franchise into a compliance, licensing, and market entry puzzle. First, it's crucial to protect your intellectual property, your trademarks, operating systems, and proprietary know-how. These need to be secured through enforceable IP rights in each target country to prevent unauthorized use and maintain brand integrity. Second, you must carefully review country-specific regulations. Different countries have varying disclosure laws, registration requirements, and pre-sale obligations that franchisors must follow to legally operate and sell franchises there. Third, adapting to local regulations is mandatory. This includes labor laws, consumer protection standards, competition rules, import restrictions, tax laws, and sometimes even foreign ownership limits. Each of these factors can significantly impact how your franchise operates in a new market. It's important to remember that maintaining uniform branding across countries doesn't mean you'll encounter uniform legal treatment. The same brand faces very different legal landscapes. So comprehensive preparation and local legal guidance are essential for successful global expansion. To wrap up, let's focus on some key takeaways. First, disclosure is crucial and must be provided before any franchise commitment is made. This ensures transparency and protects all parties involved. Next, franchise law primarily revolves around three main elements: the brand, control, and fees associated with the franchise. Understanding these helps clarify the legal framework of franchising. When it comes to liability protection, it differs significantly between LLCs, corporations, and partnerships, so it's important to choose the right structure based on your risk tolerance. Additionally, tax treatment and governance play a big role in determining the most suitable business entity. Ultimately, selecting the right form is about striking the best balance among risk, capital needs, control, and how you plan to exit the business. Keeping these points in mind will guide you toward making informed decisions in business organization and franchising.